Welcome to the latest in Thompson Coburn's ongoing series of webinars. Today's topic is preserving the attorney-client privilege in the corporate context. My name is Steve Sherman. I'm a partner in our business litigation group, and with me is John Kingston, who is also a partner in our business litigation group. In theory, there really shouldn't be any difference between outside counsel and in-house counsel when we're trying to determine whether communication is privileged. Everybody is a lawyer, they all have clients, but the reality, I think, as we all know, is quite different. In-house lawyers are frequently asked to give business advice or advice that's a mixture of business and legal advice. In-house lawyers also deal with people outside the company on a regular basis, and that oftentimes gives rise to questions as to whether or not a otherwise privileged communication was waived when it was disclosed to an outsider. There are also special circumstances, and we'll talk about those in the compliance context today, where in-house counsel are called on to conduct internal investigations and are then faced with the additional challenge of preserving privileged communications as they might relate to a discrete set of facts, the public disclosure of which can damage the company. Our goal today is to highlight some of the challenges that are unique to in-house counsel and provide you with some practice tips that will assist you in navigating those challenges. So we'll start with a basic elements of the attorney-client privilege and the work product doctrine, some general best practices that you should employ in order to preserve the attorney-client privilege. We'll talk about third-party consultants and internal investigations and the special considerations attendant in those situations and some best practices to deal with those kind of folks and situations. And then hopefully at the end we'll have some questions and we'd like to think some useful answers as well. I will turn things over to John, and John will present on some of the background things that you need to know about the attorney-client privilege and work product.
Thank you, Steve. Different jurisdictions will articulate the elements of the attorney-client privilege and the attorney work product doctrine differently. I've seen the privilege elements expressed as a 5-part test or even an 8-part test. I've seen one treatise that expresses the test for application of the attorney-client privilege in 5 parts, with each part having between 2 and 3 subparts. My view is that when you are put on speakerphone with your chief operating officer and your chief executive officer, you probably do not want to be trying to apply a 10 to 15-point test in determining whether or not that's a conversation that's going to be protected. So I try to keep things as simple as I possibly can. That being said, I see the test for attorney-client privilege as 1, is an attorney-client communication? 2, is that communication made for the purpose of seeking legal advice? 3, has it been made in confidence and kept confidential? The work product doctrine, again, I try and keep the test as simple as I can. I recognize that it applies only to documents or other material things, which does include electronically stored information, emails, spreadsheets, and the like. But again, it has to be prepared by or at the request of an attorney and in anticipation of litigation. The key questions that you want to consider when determining whether or not the privilege attaches are listed on this next slide. Who is the client is one of the threshold questions out of the box, and the tests for answering that question vary dramatically from jurisdiction to jurisdiction. Up until the early 80s, the predominant test for determining who was the corporate client was the control group test, in which case the privilege would only attach to communications between high-level employees and the counsel. In about 1981, the Supreme Court rejected that control group test, at least for federal courts applying federal law, and substituted the Upjohn Test, which is a 5-part test. I won't go through all 5 parts for you, but it basically breaks it down to folks who need to know what the communication entails or who need to communicate with counsel so that the counsel can provide effective advice. And then a variety of states imply a variant of the Upjohn test. It's called the subject matter test, which is basically, is the communication related to is the person reasonably related to the subject matter of the communication? And if the person that the corporation is, then that person can be deemed the client for purposes of determining whether the privilege applies. The next kind of core question is, why is the client talking to the lawyer? As Steve mentioned earlier, business advice is not protected, legal advice is. And so determining what hat the lawyer is wearing when the lawyer is talking to the client can become a thorny issue. My rule of thumb for deciding whether or not you are talking in a legal capacity is, could a non-lawyer provide the same advice? If somebody is coming to you with a question that could be as easily answered by somebody without a law degree or somebody who hasn't passed the bar, then you may not be providing legal advice. There are certain positions which courts deem to be, that are often held by lawyers, where courts will deem those not to be legal positions, or where the position could be filled by somebody in a non-legal capacity as well, like government relations and compliance, and it's hard to assert the privilege in the government relations and compliance context, and similar positions where you'll find companies staffing those spots with both lawyers and non-lawyers. Who else is present is a question that needs to be asked. This is a little bit different than the who is the client question. Who is the client addresses who is communicating with counsel and whether or not that communication is protected. Who else is present is who else is in the room or who else is on the email chain while advice is being given. And the scope of this is a little broader. Even under restrictive tests like the control group test, you can have folks that receive the communication, receive legal advice that were not necessarily the client, but that need to know what the lawyer's advice is, who will still be considered not to have broken the confidentiality, and the privilege will remain intact. The next question is, what steps were taken to preserve secrecy? You need to make it very clear at the time of the communication that it's intended to be confidential, and you need to be able to demonstrate that you took reasonable steps to preserve the confidentiality after the communication takes place. Work product, there are two core questions. One is, was a lawsuit expected? This is the anticipation of litigation prong, and the work that is being performed or the work product that is being generated has to be because of the prospect of litigation. The courts will vary as to whether or not it has to be the primary motivating factor or whether the work product is generated solely because of litigation, but it has to have some connection to an anticipated litigation, and the stronger that connection, the better off you're going to be asserting the work product protection down the road. And then also on work product, the last question is, are counsel's thoughts reflected? The opinions and mental impressions of counsel are absolutely protected. Work product that does not reflect counsel's opinions and mental impressions can be produced upon a showing of substantial need, and that it can't be otherwise generated without presenting an undue hardship to the party requesting it. So it is generally a good idea, to the extent that you can, to ensure that all of your work product, everything that is done at the behest of counsel, you can find a way to include counsel's thoughts and mental impressions so that you can hopefully attach absolute protection to that, to those documents and other material things. I think right out of the box, it is important to talk about limitations on the privilege. If there is anything that everybody on this CLE takes away from this presentation, my hope would be that it is an idea that you should not rely too heavily on the attorney-client privilege. There are a number of moving parts. Steve and I were talking about this before we went live, and you could actually do, I think, a semester-long course in law school dealing with just the attorney-client privilege and just attorney work product and all the variations that courts have, all the various fights that have come up in those contexts and all the different decisions that have been issued on various little pieces of that. With that much material out there, there is plenty of room for A, courts to screw up, and for B, inadvertent disclosures or inadvertent waivers to render the privilege inapplicable. So if there's anything that you take away from this launch, it would be, don't count too heavily on the attorney-client privilege. That's why the first bullet point is that most communications with counsel are not protected. There is a sense out there that if there's a lawyer on the email, that's a privileged communication. That is not the case. My sole professional function is to provide legal advice and carry out legal work on behalf of my clients. I went back and looked at my email correspondence over the last week, and I receive about 200 emails a day, and I send somewhere in the neighborhood of 50 emails a day. Less than half of the emails that I receive would be emails that I would consider privileged, and somewhere in the neighborhood of two-thirds of the emails that I send would be emails that I consider privileged. If you include the 20 to 25 emails I send a day about where I'm going to eat lunch, that number goes down even lower. I think it's also important to bear in mind that underlying facts are never privileged. You cannot cloak a fact with privilege by communicating it with counsel, and even if you can't effectively assert the privilege with respect to communication, if the other side is willing to dig enough and ask the right questions, the uncomfortable facts will ultimately come to light. Another limitation is that it's hard to predict in advance what law will apply. I think this is especially the case for in-house counsel. And what I mean by it's hard to predict what law is going to apply is that you'll have a communication with somebody in your corporation, and then whether or not that communication is privileged won't be addressed and decided until 3 or 4 or 5 years down the road. And something that before this, if this presentation was being done in-house over lunch, this bullet point would also include a parenthetical that says, courts screw this up all the time. Because it's going out publicly, I decided that discretion being the better part of valor, we'd leave that bullet point off. But courts do screw this up all the time. The choice of law analysis for attorney-client privilege is thorny, and courts get it wrong frequently by applying the law of the state where the fight is taking place, where the litigation is, as opposed to the law of the state with the greatest connection to the communication, which is where the communication took place. So if you were providing legal advice to a low-level employee in Missouri and then have the misfortune to be sued in Illinois, which applies the control group test, that communication could be found not privileged, although in my view the correct application of the choice of law rules would suggest that it should be privileged. At the bottom line, you should keep in mind that at some point somebody is going to read every document that's at issue in a privilege dispute. Push comes to shove, a judge or a magistrate or a special master is going to read the correspondence or the piece of paper that's at issue to make a determination as to whether or not it is in fact privileged. So again, there is no way to absolutely protect documents from disclosure except in very, very limited circumstances, which I would not count on. I want to talk briefly about the best practices for protecting the privilege. One of the best things that you can do on your end as in-house counsel is to educate your clients about the privilege requirements and its limitations. Something that we see occasionally, much more frequently than we should, is a communication to a lawyer where somebody at the company says, let's loop in Carl on this discussion so that this can be confidential from here on out. And just bringing a lawyer into a conversation does not make that conversation privileged. Including a lawyer on an email does not make that conversation privileged. And if your clients and your companies include you on an email for the purpose of making that correspondence confidential, all they do, they don't generate a privilege. They don't generate privilege protection unless they're actually seeking legal advice from you. And all they do, in addition to having a bad fact memorialized in an email, is have the company's efforts to conceal that bad fact by bringing in counsel also memorialized in an email. And so a lack of proper education about how the privilege applies among management can lead to all kinds of problems in litigation. And so one of the things that you can do on your end is to educate your clients about the limits of the privilege. Something that's even easier than doing CLEs for the folks in your C-suite is to just use the telephone. Most of your advice, I think, can be communicated by telephone. The stuff that needs to be memorialized in an email or a memo should be more limited, and you should spend time making sure that you memorialize it in a way that's favorable to you. But picking up the phone and making a phone call leaves a lot less of a paper trail that can be misconstrued down the road when somebody's reviewing it out of context. It's also helpful to maintain and enforce a document retention policy. Again, a document that no longer exist, there's no problem or there's no concern about that document being produced inadvertently or being produced because of a mistaken ruling on privilege or being produced because somebody inadvertently or mistakenly made a waiver of the privilege. The document doesn't exist. You don't have a privilege problem related to that document. So if you have a strict document retention policy, that makes the lawyers who handle the litigation for you happy, and it makes your job easier. You should individually label privileged communications. I say individually as opposed to having a attorney-client privilege footer in your email address or automatically part of the subject line of every email you send, because as we've discussed, the bulk of the emails that you're going to be involved on, the bulk of your correspondence is not going to be privileged. And if you are labeling as privileged communications that are not privileged, courts are going to take a dim view of your assertion of privilege. If you're careful to label only those emails or only the communications that actually are privileged, it does bolster your privilege claim. Consistency on this is important. If you are going to start labeling documents as privileged, you need to make sure that you do it consistently because, again, there's going to be a negative inference when you don't label it as privileged that it is not. In-house counsel should be careful not to mix business and legal advice. I would say you should send, I think it's easier if you send separate emails to one. If you're going to talk about both business and legal issues, I would send a separate email to address the business issues and keep the legal issues discrete. There's nothing wrong, in my view, with saying, you present some legal questions that I'll address under separate cover and then send that email separately. I think that makes it easier to protect the privilege on the legal advice. And as a practical matter, when you are in litigation, it's easier to have email on a privileged log than a redacted document on a privileged log, and you hate to have your own documents redacted in front of a judge or a jury because everybody in the room thinks that whatever is redacted is the particularly damning and unhelpful stuff, and frequently there's speculation as to the redactions is worse than what the actual redacted text is. So as a person who is not a fan of redactions in litigation, I would prefer to keep legal advice wholly separate from anything else so that you can withhold the whole document. It's important also to pay attention to your email distribution lists, especially in Illinois, Maine, New Hampshire, Hawaii, and Alaska. Those are the states that I think still apply the control group test. Now, as I said, under a proper application of the control group test, there can be non-high-level officers on the distribution chain without breaking the privilege, because that's a confidentiality question, not a who is the client question. That said, it's easy for courts to screw that up, and they often do. So if you pay attention to your email distribution list and make sure that there's nobody on there who doesn't really have a need for the information or who you can't articulate a reason why that person was on the list, I think you'll be well served. Use the correct language in your communications and in your memos. To the extent that you can make the court's job easier, to the extent that you can provide the court with a path of least resistance, I think it's helpful for you to do so. So if you can say that the buzzwords are, my advice on legal implications. You asked me for my legal advice on the following. Because this is likely to be litigated, you'll see that there's a bullet point there that a litigation hold is critical. What you do not want to have happen is to have somebody on your end using the right buzzwords to establish the work product doctrine, saying this is obviously in anticipation of litigation, and have you not preserved documents in anticipation of litigation. So it is important to use the right phrases, but it's also important to make sure that you're taking the right steps to prepare for litigation. And then, again, language like do not copy or forward is also helpful to show that you're trying to control the circulation of the document at issue, and so if it gets to people that it shouldn't have been, it's not a knowing waiver on the part of the company. It's some employee doing something that they shouldn't. One other thing I would just kind of note on that, the assertion of the attorney work product doctrine, as I was just thinking about this morning, is this is also an issue for deposition preparation. Usually, something that happens all the time in a dispute between a couple of companies is early on in the deposition, I like to ask somebody if they were planning on suing my client at the time they were entering into the deal or early on before things had kind of blown up. And a lot of times you'll get a witness that says, no, we weren't planning on suing that client. And then it's a very easy follow-up question that, so you didn't anticipate any litigation at this time. And then the witness says, no, they've just broken their work product protection for a lot of potentially helpful documents. So this isn't really a document labeling piece of advice. It's more of a deposition prep piece of advice. But I think it's useful for you to bear that in mind. I think I'll turn it over to Steve, who can talk to you a little bit about internal investigations and working with outside consultants.
Thanks, John, and I'm pleased to hear that you're so sneaky in depositions. One quick reminder, there's a chat box on your screen if you want to submit questions. We'll happily answer them at the end of the main portion of the presentation. So with that background about the attorney-client privilege, I think it's important to keep in mind that the privilege as originally constructed in the corporate context assumes that employees only of the corporation are the clients of the in-house lawyer. But I think all of us know that in reality, in-house counsel is required to work with lots of folks who aren't directly employed by the company or perform as an independent contractor in some fashion of the company, but yet at the same time are providing advice on almost a day-to-day basis. And we could certainly spend, I think, several days talking about different types of employees or consultants or outsiders and how that impacts privilege. But I think for today we're going to break it into really three kind of chunks that I think you can lump most relationships into. The first of these, and I think the one that creates a lot of confusion and there's a lot of case law about, are auditors. The general rule with respect to outside auditors is that sharing a privileged communication with or including an outside auditor in a privileged discussion typically will waive whatever privilege might have attached to that communication. That's true of ordinary course work by an auditor. So to give a quick example, if you have a board of directors meeting, you take minutes at that board of directors meeting, the auditor is not present, and then during the course of an audit, the outside auditor asks for those board meeting minutes. Those board meeting minutes, if provided in unredacted form to the outside auditor, will waive the privilege, even though it was a privileged conversation that is memorialized in those board of directors meeting minutes. Now, there's a slightly different rule that applies to work product protection, and I think it's important to take a little bit of a detour here and talk about what I think is a particularly interesting case on this topic, because many of us are frequently faced with a situation where outside auditors in the course of an annual or quarterly audit want us to provide them with a memo or discussion about a legal matter that has been memorialized in some way in work product form. And the Deloitte case is particularly interesting because it has a nice discussion about how work product waiver works in that context, as well as containing some helpful sound bites that you can use in the event that your privilege claim or work product claim is challenged with respect to a memo. The Deloitte case actually came out of a tax litigation matter between Dow Chemical and the IRS, and in the particular matter at issue was whether or not the IRS could successfully subpoena from Deloitte two memos, one prepared by in-house counsel and the other by outside counsel, concerning the tax treatment that would be applicable to two different Dow Chemical subsidiaries. Deloitte had, during the course of its regular audit several years before the litigation, actually compelled the production of the two memos from Dow, and they did so by refusing to issue an unqualified opinion as to Deloitte's financials until Deloitte provided the memos. Until Dow provided the memos, and the reason Deloitte wanted them was because they wanted to see whether or not an adequate reserve had been set around the tax treatment of those subsidiaries. When this matter got to the D.C. Circuit, the D.C. Circuit ultimately concluded that the memos were subject to work product protection and could not be subpoenaed by the IRS. And in doing so, the D.C. Circuit made a couple of interesting observations. One is that the D.C. Circuit concluded that even though there was a significant potential for an adverse opinion from Deloitte or a future dispute between Deloitte and Dow, that did not make the auditor an adversary of the type that a work product waiver would contemplate. So in other words, Deloitte, by receiving the documents, wasn't an adversary that Dow needed to be worried about later seeing a document or suing it. The other thing the D.C. Circuit held was that Dow had a reasonable expectation of privacy when it turned the memos over to Deloitte. Now, ordinarily, we probably would think that that grew out of the relationship itself, but in actuality, the D.C. Circuit found that that expectation of privacy was rooted in the American Institute of Certified Public Accountant Code of Professional Conduct. So an interesting source in order to generate an expectation of privacy. And the D.C. Circuit also expressed some concern that an outside auditor could functionally force waiver of a sensitive document otherwise protected by the work product doctrine by refusing to issue an unqualified opinion. And I think the Deloitte case is particularly interesting because not only is it a circuit level case when most of the cases that deal with these issues tend to be district courts, but it also provides you with some protection when you're in what I think we have found is an all too common situation where there's a significant litigation matter that's contemplated by the company and the company's outside auditor is pressuring it to turn over a confidential document prepared by an attorney that discusses something that might give rise to significant liability on the part of the company. So I'd encourage you to take a look at that case the next time this issue comes up. It's quite helpful. To swing back to the notion of waiver with respect to privileged communications with auditors, you can, of course, separately engage an auditor to assist you in providing legal advice. The real distinction that I'd ask you to keep in mind here is ordinary, regular course, quarterly, yearly audits. Generally, those kinds of communications, when you provide them, are not going to be found to be privileged. But if you can figure out a way to carve out a separate engagement, and we'll talk about this shortly, that's a good way to make sure that you're insulated from risking waiver in the future. The other situation that we want to talk about today are non-employees and outside experts that companies use to provide assistance. This is commonly called the Colville Doctrine, and that comes out of a case that was decided about 60 years ago now in the Second Circuit, which recognized that an attorney can share privileged information with a consultant, and that rule has since been expanded to include accountants, financial advisors, investment bankers, when that person is necessary to render legal advice. So, for example, provide assistance in interpreting part of the IRS code, or somehow or another adds value. A typical example that I've seen in some of the cases is an interpreter who can help when a client doesn't speak the same language as an attorney. Now, as you might imagine, necessary to render legal advice or adds value are extremely fuzzy standards. There are a host of conflicting opinions on whether or not a waiver in one circumstance will occur or not, and it pretty much depends on what court you're in, and so we'll talk a little bit about how to protect against that problem, which John identified earlier, that courts frankly sometimes just don't understand these issues. Another kind of outsider that companies deal with on a regular basis are folks who act as a consultant or an independent contractor like a salesperson. In those situations, when you're considering whether or not you want to share a privileged communication with that person, what a court's going to ask later is, was the person functionally an employee of the company? What was the nature of that relationship, and how is it memorialized? Again, this is a largely fact-specific analysis, so it's important to be cautious when you're communicating with these people and make sure that, again, you've sort of memorialized the relationship in some way so that you can later point to a limitation on the relationship or the closeness of the relationship and preserve privilege. So how do we best make sure that a court's going to rule in our favor after we've been working with an outsider? Well, the consistent thread that runs through the cases that have found the waiver occurred is that the corporation that is claiming the privilege was able to provide evidence in some fashion that the engagement was done at the direction of counsel or was for a separate purpose than the outsider's ordinary purpose relating to the company, or in the case of a consultant, that the consultant was functionally an employee. So, and you'll hear this word from us, I think, a lot, memorialize the scope of the engagement. Write it down. Make sure that you have a separate engagement letter for the matter that you are consulting with the outsider on, and that you control and supervise that work throughout. So the engagement letter should state, for example, that the engagement is being done at the direction of inside counsel and should identify who the inside counsel is. It's important also to reaffirm the scope of the engagement periodically. What frequently happens is that the engagement can morph in terms of what it's about, or it can last for an extended period of time, and it's important to, in some fashion or another, even if it's just an email between you and the outside entity, make clear that the engagement has a specific scope and that you as in-house counsel are controlling and supervising the work that's being done. The other point I would make, and this is a pretty simple one, is make sure that you're keeping the documents that define the scope of the engagement. There are a number of cases where, for whatever reason, the document that memorialized the engagement was no longer in existence, which means that in-house counsel was required to submit an affidavit, and sometimes that is enough. But as in-house counsel, you probably don't want to be in the position of submitting an affidavit or a declaration that defines and details the scope of a particular legal issue or relationship, and then make yourself potentially susceptible to examination in court when there's a motion to compel. The other circumstance that we wanted to talk a little bit about today is how to handle the very specific notion of an internal investigation. These obviously provide another unique challenge, and there's a tension that is inherent in these, which is that we always want to preserve privilege. We want to make sure that any communications that we have between employees and in-house counsel aren't disclosed, as well as our communications between in-house counsel and outsiders aren't disclosed. That's particularly the case when we're talking about a public company and an investigation that concerns a practice that took place over a long period. However, at the same time, at some point during an internal investigation, particularly if it concerns a matter of significance in terms of dollars, you are going to want to consider whether or not you're going to have to self-report to a government regulator. So you need flexibility so that if you can turn some of those attorney-client privilege communications over to show the government that you fully investigated and taken remedial steps in order to clean up a problem. And where this tension is probably the most present is when you're interviewing an employee. The thing that you want to make sure that you're not doing is creating an impression in the employee's mind or an in fact joint representation in which both the employee and the company are the client. That's when you want to use what has come to be called an Upjohn warning. I think in some of the cases you'll see it called a corporate Miranda warning, and that's essentially a statement from the lawyer to the employee that's being interviewed that you represent the company, not the employee, the purpose of the interview, that the interview is privileged as between the company and the attorney, and that it's confidential for that reason and can't be disclosed by the employee, and that the company, not the employee, controls the privileged information and can disclose the substance of the interview to a third party without the employee's consent. Again, the purpose of this is just to make clear that you are to the employee that you don't represent the employee, that it's not a joint representation, so that later if you want to turn the substance of that discussion over, you don't need the employee's consent. What will happen a lot of times after you do that is the employee will then ask you whether or not he or she needs a lawyer. A little bit of a cautionary note here. When that happens, keep in mind that Rule of Professional Conduct 4.3, which in Missouri we call Rule 4-4.3, requires you to make your interests clear and to the employee and correct any misunderstanding that the employee has about your role. So you actually have an affirmative obligation to make sure the employee understands that you don't represent him or her. So if the employee asks that, again, make clear that the company is the client. And above all, don't tell the employee that he or she does not need an attorney. That will oftentimes give rise to an assumption on the part of the employee that you are his or her attorney, which means that you run the risk that a court will later find that there was a joint representation and that therefore you can't turn information that you received from the employee over to an authority without the employee's consent. Now, a lot of times after this is done, you may also find yourself in the situation where the employee refuses to assist. And I think those of us who have done more than one internal investigation have actually had an employee tell us that they are refusing to help us, or they are insisting on asking for their own attorney. So, well, what do you do in that situation? There's no Sixth Amendment right to have an attorney present if you are an employee and your boss wants to ask you some questions, or in-house counsel wants to ask you some questions. Refusing to submit for an interview standing alone is also not a protected activity. So you are on strong legal ground as in-house counsel if you want to advise your client later to go ahead and fire the employee certainly in most circumstances. A better tack, though, is to allow the employee, if possible, to consult with an attorney. You're much more likely to get a cooperative employee in that context. If there's litigation later, you want to be able to tell the court that we certainly provided the employee to talk with someone. So a firm sort of response that they're free to consult with an attorney, but you expect that they'll assist the company in its investigation is, in many instances, the best answer. What I personally try to do to avoid this from happening is, from the start, I will tell an employee that I'm interviewing that I'm only interested in figuring out what happened and working to correct any problem that might exist or help the company figure out what to do going forward, and I'm not really interested in looking to get anyone into trouble. That's almost always the truth, and so what I found that it puts employees at ease and makes it more likely that we'll be able to have a full and complete interview without having to wait for a period of days while they talk to an attorney. Now, at some point, you're going to think about turning information that you've obtained in an internal investigation, including privileged communications, over to a regulator. If you're in the Eighth Circuit, you're in luck, because the Eighth Circuit still recognizes the concept of limited waiver. In other words, you can waive the attorney-client privilege with respect to communications that you provide to a government official without waiving the substance of those communications to anyone else, most notably a plaintiff in a civil class action that concerns the company practice that you are investigating. However, that's the law in the Eighth Circuit. It's not really the law any place else. Every other circuit that's taken a look at this has determined that that limited waiver is not a good idea, and that's antithetical to the notion of attorney-client privilege in the first place, and has refused to recognize it. Federal Rule of Evidence 502 is a slight modification of the rule. I wouldn't really count on it to protect you in these situations. It essentially protects undisclosed material that isn't related to the material waived. I think all of us who have done these things will tell you that occasionally what you get is a situation where you start investigating a bunch of different things, as the investigation can sometimes spin off into different areas. Arguably, Rule 502, which also can allow you in some instances to actually get a court order to protect material, can protect those kind of spun off separate areas that you don't disclose to the government on. But we're still kind of living in a world where once you turn it over outside of the Eighth Circuit, you've turned it over as to everyone. So how do we make sure that we're protecting the privilege once we start an internal investigation and still maintain some flexibility? Well, the first thing I would tell you is that from the outset, you really have to develop a plan and make sure that you have clear and consistent goals that are communicated to everyone who needs to know. And that's an important caveat, because you want to make sure that you're limiting your internal disclosures to those who need to know. Think about whether or not at the end of the investigation are we going to be in a self-reporting situation. Not every internal investigation is going to involve a company practice that's regulated. Many times internal investigations involve wrongdoing on the part of an employee, and they just simply end with the termination of an employee, and there's no need to turn the information over to someone outside the company. So that's an important thing to keep in mind. The other couple of pieces of advice here: make sure that the folks that you're using, particularly the outsiders, are of the type that will allow you to preserve the privilege. For example, if you are investigating an accounting practice, in many instances it makes sense to think about using an outside auditing firm that's different than your ordinary course auditor, so that you can create a separate limited engagement as to the matter that is the subject of the internal investigation only, and make it clear that what the outside auditor was doing was helping you provide legal advice to the company. And that way you'll be more likely to be protected from the cases that have held and the law that has held that disclosures to outside auditors automatically work a waiver. Similarly, if it's a practice that involves a legal interpretation of a regulation, give some thought to employing separate and special counsel for the purpose of the investigation only, so that you aren't faced with a situation later where the attorney's advice at the time the matter that was at issue was being decided is somehow subject to a separate exception, or perhaps you'll be in a situation where you want to rely on that advice and you have to work a waiver in the first place. And again, make sure that you're memorializing all of these elements as best you can. Tight, consistent engagement letters memorialize the elements of the privilege in the context of the Upjohn warning. One of the things that we've seen more and more, and that we've actually employed here with a fair amount of success, are written acknowledgments that an Upjohn/corporate Miranda warning was given. That seems somewhat counterintuitive. I think most of us would think that employees at a company would not want to sign an Upjohn warning or an acknowledgment that they've been given one. Somewhat surprisingly to me anyway, we found that employees will happily sign those when you're starting an internal investigation, and that is something that you can point to later to demonstrate that there was no joint representation. So it's important to make clear what your goals are, determine what you think the outcome of it's going to be, and create some documents that memorialize in detail and in a very tight way what the notion of any representation or assistance that you're getting is. And I think that's pretty much what we have today, and I think if there are questions, we'll happily take them. Well, John, one question I had for you before we start getting to the questions that I was thinking about when you were talking was email strings and that are shot around from employee to employee and then forwarded to in-house counsel. What's the best way to kind of handle that situation, and what do courts tell us about those?
Sure. A couple of things to keep in mind with email chains. The most important thing is that each piece of an email is a separate communication. So you have to go through and analyze each piece of a chain. And as we know that email chains can have 15, 20, and up little pieces to it as people just keep adding on to the same chain. Every one of those is going to be analyzed separately. This came up in a not too recent case, or a not too distant case, involving Microsoft, where there was one out of 1.7 million documents. One was an inadvertent production of an email chain that was started by a question posed by in-house counsel. There was a motion to compel filed seeking the production of that email and then related emails, arguing waiver. The court, in my view, correctly found that there was no waiver by that inadvertent production because it was obviously not a knowing waiver. But then the court went on to find that only that very first email in the email chain was protected by the privilege. And so that the first email from in-house counsel was redacted, and then everything else was ordered produced. In addition, the lawyers from Microsoft had to go back through their privilege log, and all the documents that had been logged as privileged were one piece of the email chain was privileged. They had to be redacted, and the privilege analysis applied to the entire chain on a email-by-email list. So again, in addition to what we've sort of discussed earlier about keeping track of your distribution list, be aware that as emails are widely disseminated and as more and more people reply to the same message, that you're increasing your analysis for each succeeding message in the chain. Turning to some of the questions. There is a question asking if disclosure to a government official is required by law. Is there still a waiver? What if the law specifically preserves the privilege by providing that submission of the information is not a waiver? I think that the correct view of this, and I'm happy to defer to Steve on this as well, but any kind of a disclosure that is a forced disclosure is not a waiver because it's not voluntary, is that the correct view of the law. The problem that I think you bump into isn't on the waiver piece, it's on the confidentiality piece of the privilege. If the document was kept confidential but the confidentiality is broken, at least that document, there's a pretty good argument that it's no longer privileged because it's no longer confidential. Although the Eighth Circuit, as Steve has mentioned, is pretty good for selective waiver, and you can make a good argument that you should be able to, at least in this jurisdiction, that you should be able to preserve the confidentiality of that document.
One of the other questions is whether or not audit letter inquiries are, a response to an audit letter inquiry works a waiver of the attorney-client privilege or the work product doctrine. It typically does not. The ABA treaty, it covers this. I think that there are obviously ethical rules that are around what can be disclosed in an audit letter to outside auditors, but the rule is that responses to audit letters are protected by the work product doctrine, and the disclosure of that information to auditors does not otherwise waive applicable protections.
We have another question asking if the employment structure of the in-house attorney, asking about how the employment structure of the in-house counsel can affect the privilege, where there are multiple companies represented by the same in-house attorney, only one of which pays the in-house attorney. I think you can handle that the same way that you would handle one lawyer representing multiple clients. What you would want to do is you want to memorialize that the lawyer's representing everybody, and that the lawyers, that all the boats are aligned in the same direction, that the counsel for all of the folks that are in the corporate family. And then what I think would be an important thing to do is address what happens if a conflict arises between those corporate entities. In the case of a conflict, you want to anticipate that and figure out who the in-house counsel is representing if by chance there is a dispute among those corporate entities. And you want to think about that before, and so that you can get the waivers that you need to handle that joint representation among the different corporate entities. But my view is the best practice would be to formalize that representation.
Another question is, when trying to maintain confidentiality of electronically stored information, does it matter that a company's IT staff would have access to and regularly see the data? That's an interesting question. I can't think of a case off the top of my head where that's come up. I can't imagine that it would work a waiver for a couple of reasons. One, typically what an IT person's doing is they are just, it's a passive review. If it's a litigation matter, they're assisting in-house counsel in providing advice to the company. 3, I don't think that you could say that an IT person was an adversary such that a knowing waiver could be made. And then I think 4, you would look at the line of cases that we were talking about earlier, which use as an analysis whether or not the person is an employee of the company, and I think that the answer to that would be yes. So I can't see how it would work a waiver of the privilege IT staff viewing electronic information, although it's certainly an interesting question. Since there are no more questions, and I think we're done with our portion of the presentation, we'd like to thank everybody for joining us today. And if you have additional questions, I think both my and John's contact information is at the beginning of the slide, and we're happy to answer any questions that you might have that you might want to think about and talk to us later about, or at any time in the future. So thank you very much, everyone, and thank you for joining us today.